Well, thank you, everybody. Welcome to the Hoover Institution's Johnson Center, the Hoover Institution's outpost here in Washington, D.C. Delighted to have you all here today to talk about a great, fascinating book written by a friend of mine, which is always a pleasure. But before we talk about Josh and his book, I just want to introduce the speaker series in general. This is part of a new series we're charting out called Opening Arguments, Conversations on American Constitutionalism, the goal of which is to bring together a variety of authors and other intellectuals and policymakers to discuss constitutionalism in the broadest sense, not just what happens in courts and in legal briefs, but what happens in the day-to-day workings of American government, and to try to think of it in the broader constitutional picture. This builds on a number of speakers we've had in the last year here, ranging from Senators Lee and Senator Hatch to Professor Randy Barnett, Hoover Institution Fellow Lonnie Chen, Tevi Troy, and others. And in fact, we'll be announcing a series of scheduled speakers soon, but tentatively, it looks like we will have the Washington Free Beacon's Matt Continetti in March to talk about populism and Trump and the bureaucracy. In April, Professor Hadley Arkus to talk about natural law, the court, and the Constitution. And in June, Professor John Inazu to talk about his recent book, Confident Pluralism. So please stay tuned to the Hoover Institution's website for more announcements on this series and other speakers we hope to announce soon. There's a sign outside in the lobby that quotes President Hoover's mission statement for the Hoover Institution when the Hoover Libraries became the Hoover Institution. He wrote this to the Board of Trustees in 1959. This institution supports the Constitution of the United States, its Bill of Rights, and its method of representative government. Both our social and economic systems are based on private enterprise, from which springs initiative and ingenuity. Ours is a system where the federal government should undertake no governmental, social, or economic action, except where local government or the people cannot undertake it for themselves. He concludes, with these purposes as its goal, the institution itself must constantly and dynamically point the road to peace, to personal freedom, and to the safeguards of the American system. And our goal with this speaker series, Opening Arguments, is to be true to Hoover's mission, and again, to think about constitutionalism in the broadest possible sense. And in that respect, it's a real pleasure to start this with Josh Blackman. Josh, as I mentioned, is a friend of mine, but more importantly, he's a professor of law at the South Texas College of Law in Houston, where he teaches constitutional law, and he's an expert on the Supreme Court. He's written what I'd call a tidal wave of law review articles, essays, op-eds. He's indefatigable. I've never known anybody who writes more than Josh. And nobody can keep up with the intellectual penetrations he's made into some of the most challenging legal and constitutional issues of our time. He's an adjunct fellow at the Cato Institute. He founded the Harlan Institute. He also founded Fantasy SCOTUS, in case fantasy football.
Exactly what it sounds like.
It's
we called Gorsuch.
You did call Gorsuch?
Called him in November.
Really?
We did.
Oh, I should have made a bet.
Should have.
He's testified before Congress, and most importantly for today's purposes, he's the author of two fantastic books. The first one, which came out in
September?
No, the first one was
2013.
2013, is called Unprecedented, The Constitutional Challenge to Obamacare, which is, I think, the definitive book on the history of Obamacare, the Affordable Care Act, and the constitutional challenge to the individual mandate. And now Josh returns with his second book, Unraveled, Obamacare, Religious Liberty, and Executive Power.
This book's getting bigger also.
That's right. I guess that is true, isn't it? So the third book, and this is the first two of a trilogy.
It will be a trilogy.
The third one will be about that. We'll have to break up the discussion into two lunches. But let's actually just begin with the title of the book. What do you mean by Unraveled?
This title really arose in a period in 2013 when the healthcare.gov website launched. There have been so many efforts to build up this law and discuss how amazing it's going to be, but in a short period of time, the weakness of government became utterly clear, how they were unable to even execute a simple website. And in my mind, this was really a harbinger of how they would try to take over a significant portion of the United States economy, which was the healthcare market. And the law was indeed falling apart, unraveling. I didn't know when I wrote this book over the past year or so how unraveled it would get. And leading up to the presidential election, much of the law started to crumble. Insurers started fleeing markets, premiums were going through the roof, and it became clear that the law was not sustainable. So much of the current debate over repealing and replacing the ACA is premised on this law working well. Had Donald Trump never been elected, President Clinton would be stuck with a very big situation right now of a law that doesn't work. And I fear that the repeal and replace panic is obfuscating what is actually underlying this ACA.
And what is that?
The biggest problem with the ACA is that it's based on a presumption that the government can control markets. People are nodding their heads. This is what Hayek would call a fatal conceit of central planners. If we get the subsidies at this level, and we have the mandates at this level, and these regulations, then poof, right, everything will magically work together. The fatal conceit of Jonathan Gruber and his ilk has become evident. They assumed that if they imposed a mandate, a penalty on people for going uninsured, people would flood to the marketplaces, and it simply hasn't. People have been rational and said, well, I'll pay this penalty. I don't want to buy expensive insurance that's worthless. Or if you're really smart, they'll find a way to get an exemption from the government and not even pay the penalty. So the levers and mechanisms used to prevent the implosion of the insurance market didn't even survive 3 years in.
Now, just to be fair, Congress passes law all the time that dictates outcomes. Mm-hmm. And in this case, the Affordable Care Act, as I understand it, the structure was less about dictating outcomes and more about creating market mechanisms or using market mechanisms and penalties and subsidies to try to, say, to use the common word now, nudge people in the preferred direction. What made this so unprecedented, to use your last book's title, compared to every other federal program that we live with today?
Indeed, the reason why the ACA was unprecedented was because this law compelled people to buy a commercial product. The government has long attempted to regulate people already in the stream of commerce. This law was novel and said, even if you're sitting on your butt at home doing nothing, you are now compelled to buy health insurance. And not just any health insurance. Even though it's purportedly market-based, the law gives very strict guidelines. You have a gold plan, you have a silver plan, you have a bronze plan. If it doesn't fit in that bucket, too bad. And it inhibited markets from actually deciding what sort of policies people want. It was built on the presumption that people are stupid, they're irrational, they'll buy some cheap policy and then they'll get in trouble later. We're smarter than that. We'll make them buy a strong policy now with a serious deductible and a serious everything. And that way, in 25 years, if they get hit by a bus, they won't have any problems. And it took away from people the choice of making perhaps what's a dumb decision in the long run, but in the short run is a rational decision.
Now, your first book focused specifically more than anything else on the individual mandate and the constitutional challenge to it. But in your new book, as you're tracing what you see as the unraveling of the program, it's not the individual mandate per se, it's the regulatory framework that surrounds it.
Right, and this is really the crux of the second book. To sell the ACA, President Obama made a promise a number of times. You've heard this promise. If you like your plan, you can keep your plan. Now, why was this promise so important? Hillary Care in the 90s, you may recall, for those alive in this room, most of you were. I think my students weren't alive for that anymore, but I think most of you were alive for Hillary Care. Failed because under Hillary Care, a government lawyer would decide which doctor you get, and people didn't want that, which is why they said, listen, we've got our butts kicked in Hillary Care. Let's say you can keep your plan. But the problem was Obamacare was premised on people not keeping their plans because their plans were wasteful and getting people onto these streamlined, government-approved insurance plans. So what happened was when the rubber met the road, in 2013, as millions of Americans got these sort of cancellation notices, the regulatory framework went to hell. The government started granting these waivers and exemptions and suspending mandates and basically having this ad hoc governance, what I've called government by blog posts, where every single week there was a new thing, a new exemption, a new way to change the laws. And this really undercut the core of the law. Indeed, I said this often, Barack Obama did far more than Ted Cruz ever did to destroy Obamacare. The sort of exemptions and waivers he granted were extremely deleterious to the core of the law. Ted Cruz couldn't even touch what Obama did through executive action.
Now, when you say they're deleterious, compared to what, right? If he hadn't, and I do want to get into this point that you describe as government by blog post at some point, but as the Obama administration was making these adjustments, either in rulemakings or in guidance documents or in blog posts, the alternative, the status quo, are you saying that would have been an improvement upon the changes they were making along the way?
In the long run, actually, yes. Obamacare was bitter medicine, and the way this law survives is by forcing a lot of people into the risk pool. By creating all these exemptions, you actually kept a lot of health people out of the risk pool, which resulted in even higher premiums. In other words, bite the bullet, right? If in that year, a couple million people were inconvenienced, you've actually had probably 20 million people buy into Obamacare. Instead, maybe 10 million people bought in, and it wasn't nearly enough to make the law sustainable. So these short-term efforts to keep things stabilized, so to speak, actually in the long run undercut the economics of the law, right? Jonathan Gruber didn't anticipate that 10 million people would get exemption from the mandate. That wasn't part of the calculus, and that basically made the entire ACA unstable within a very short period of time.
Okay, before we get into the trajectory of adjustments along the way, I want to pick the story up at the end of your last book, because again, the first book was focusing on the individual mandate and the constitutional challenge to it. And that case, famously, NFIB versus Sebelius, I mean, there were some wins for the challengers in there. They had challenged Medicaid expansion on federalism grounds, effectively, and they won there 7-2, right?
7-2.
And then a little bit more complicated was the core challenge to the individual mandate. The case had really, first and foremost, been a Commerce Clause challenge to the individual mandate, and there were 5 votes on the court to say that this individual mandate was not a lawful exercise of the constitutional power to regulate commerce. But the individual mandate didn't go away, because there were also 5 votes on the court to hold that it was a lawful exercise of the constitutional power to tax.
Thank you, John Roberts.
But your first book ends on a very optimistic note, and this is from the penultimate discussion in your book. You're reflecting back on the litigation, NFIB versus Sebelius. And you said, what made the evolution of NFIB versus Sebelius, the litigation from the time it was filed to the time the Supreme Court decided, what made it so unprecedented, at least as far as constitutional litigation goes, is the seamless union at all levels of government and the populace of the theories and the movement. The political and social climate in which this case came of age created a veritable perfect storm for this challenge. And then you looked forward and you said the challenge to the ACA, NFIB versus Sebelius, should serve as a playbook to halt future expansions of federal power. Only time will tell when this movement will be replicated, perhaps to even greater success. So how did it work out?
Whoops. You know, I think I ended that book on a very odd note of optimism, perhaps. I was under the impression that Barack Obama would win re-election in 2012, and he indeed did. And I thought that once Mitt Romney lost, that would make the repeal effort basically a done deal. I thought, well, you know, we had our shot with the Supreme Court. Everyone's going to start loving Obamacare. It's going to be great, and then I won't have anything more to write about. That didn't happen. But to Adam's question, which he picks out a very good point I haven't read in almost 4 years, the playbook used by the Republicans in the Obamacare cases was brilliant. And I don't say that because I was loosely affiliated with it. It was very smart. You had this movement, the Tea Party, remember them? And they weren't just ranting about government because they hated government. They had a theory of the Constitution. They said, the government can't make me buy health insurance. The government can't make me buy broccoli, if you remember that. And you had this perfect confluence, this perfect storm between a constitutional theory, which Randy Barnett and others articulated, a gap in precedent the Supreme Court had never addressed, whether you can make someone buy a product, and you had this Republican backing of the movement. And all these things came together to make an argument that was laughed at, plausible. I think we're seeing it like now, like 2 blocks away at the White House, basically, where we're seeing the resistance, right? The resistance to President Trump is now clamoring for federalism, right? Can you imagine? These Democrats who've been laughing at us for decades, saying James Madison, our patron saint, right? We have to worship James Madison. And they're trying to have a similar popular constitutionalist movement to assert federalism as a check on Trump's immigration policies. And I don't know if they're taking a playbook out of this book, but it looks a lot like it.
I mean, I wasn't teasing when I read that quote. I think you made a very good point that the story of the first litigation was this seamless union between litigation and serious intellectual scholarship and political debate and populism. And after that case, the win and the loss, we then saw a series of lawsuits in what we call sort of the realm of administrative law, challenging the outgrowths of what followed next from the Affordable Care Act. And the cases, the famous ones were King v. Burwell, the challenge to the health care subsidies and penalties in the insurance exchanges, and then the religious liberty litigation. I want to get into both of those. And by the way, think of questions, because we will turn it over to you and have microphones so you have chances to ask your own questions of Josh. But as you're thinking of these, let's start with the King v. Burwell case, the Affordable Care Act exchanges. How did that arise?
So one thing that people don't realize about the ACA is that the law that actually got enacted was a draft. Go back to 2009. After the election of Al Franken, the Democrats had 60 votes, 6-0 exactly. And that meant they could kill any filibuster. So on Christmas Eve, December 24th, 2009, the Democrats passed a version of the bill in the Senate. This was not meant to be the final version. It was literally a draft. And there were lots of errors, lots of things they could have cleaned up. It was a draft. But then the unthinkable happened. Scott Brown, a Republican, won a special election in Massachusetts. With that, the Dems lost their 60th vote. And they were like, uh-oh, what do we do? So the House then basically passed the Senate version of the bill, and they made some minor changes through the reconciliation process. But there were a lot of things in the Senate bill that were never meant to be final, one of which involved exchanges. Under the Senate bill, states were allowed to establish an exchange, and if they failed to do it, there was a federal fallback. The House bill, in contrast, only had a federal exchange, so it was not even an option. Why? Because Nancy Pelosi didn't trust Ted Cruz and John Cornyn to build a good exchange in Texas, which is probably a reasonable belief because states don't administer Medicaid as well as other states. But they couldn't get that in because they needed the Senate bill. As a result, here was a provision of law. A state can build an exchange. If they fail to do it, there's a federal exchange to back up. But there's this one provision, Section 36B of the law, which says subsidies on the exchange are available, quote, on an exchange established by the state. Okay, if an exchange is established by a state, you get subsidies. So if one were to read that, one would think that if you buy insurance on a state exchange, you get subsidies, and if you buy it on a federal exchange, you get nothing. In fact, it's not even clear if the people in HHS actually read the damn bill. A benefits lawyer by the name of Tom Christina in South Carolina actually read the law and said, wait a minute, we got this provision here. That got picked up in Bloomberg. And then HHS said, wait a minute, this guy Christina's finding this link. So the government issued a rule saying we will treat the federal and the state exchanges identically, treat them the same way. It was challenged in court, went to the Supreme Court, and in another decision where John Roberts breaks my heart. He breaks my heart every June in a different way. I don't know how, but every way he finds it, every year, a different way to break my heart in June. It's without fail.
Oh, stay tuned. It'll be great.
Oh my God, it's going to be terrific. It's going to be amazing. It's going to break my heart for the next 40 years. But how did he break my heart this year? He said, well, the plain meaning of the text is strong, but we have to read the text as a whole. And the purpose of the ACA is to improve health insurance, not to destroy it, and we will read it to improve it. So subsidies are available for everyone.
So what was interesting about this case was it wasn't a constitutional challenge in the sense that the challengers were trying to strike down the statute. It was administrative law infused by constitutional values of federalism and so on. And how did that broader sort of constitutional debate, you think, inform the Supreme Court's approach?
Right. So there was a federalism angle to the case because the idea is this: if indeed subsidies were not available, right? If you couldn't get a subsidy, if a state failed to establish an exchange, that would leave the people in those states in a very, very tough spot. Obamacare has made insurance unaffordable without subsidies, by the way. That's why people who make a lot of money can't afford insurance, right? Insurance is through the roof when it's unsubsidized. So there's that. But going back to the question Adam asked, it gave states this choice. Either build an exchange or we will make it impossible for your residents to buy health insurance because it will be too expensive. And a number of progressive scholars who found federalism, you find Christ, they found federalism, put together this brief and said, well, wait a minute, Justice Kennedy. It wasn't addressed to him, but it may as well have been. Wait a minute, Justice Kennedy. If you adopt this reading, you're putting the states to a tough choice. Build an exchange or bankrupt your citizens. It's a very tough argument to square away because the only reason we're in this mess is because of Obamacare's regulations in the first place. Had this rule never been promulgated, those people would not have been subject to a mandate and they would have not been bankrupted, right? If you're not subject to the mandate, you can buy whatever insurance you want. So it only happens that people lose their insurance because of this Obama-era rule that's been in effect for nearly 2 years. Also, not to get into the weeds, but most of these cases involving federalism are the states qua states, not the states qua the individual. So the doctrine didn't even go that far, whether withholding money from the state could harm individuals. That's like not, that wasn't even like the precedent.
It was interesting. I was in private practice still at the time, and we filed an amicus brief in the litigation, and we were also raising federalism issues on the other side, and we were sort of chuckling amongst ourselves that the most effective federalism brief in the case was the federalism brief in favor of the executive branch over the objections of states. But
Remarkable, isn't it?
It was a very powerful brief, and there were other administrative law issues in there, Chevron deference and others, which we don't have time to get into, but I thought it was an interesting case all around. I'm curious, though, like you said, the first case, NFIB, was a legal case informed by politics and intellectual scholarship. And I wonder if one of the takeaways from the second case, King v. Burwell, was that the politics surrounding the case undermined the case, in that from the moment that Tom Christina recognized this provision, there seemed to be this wave of enthusiasm on our side of the case that this was going to be a silver bullet that was going to take down Obamacare. And do you think that maybe activists on the challenger side of the case maybe spiked the football so early and so loudly that they actually undermined the lawyer's work? Did you get a sense of that dynamic?
Yeah, this case was driven entirely by a desire to kill Obamacare. The lawyers behind the lawyers, Mike Harvin, Gus Jones, these are very good lawyers. And I'm not trying to mock their work. Right. And I think they put together a pretty compelling case, but let's not quibble. This was designed as a way to kill Obamacare, and specifically kill the law's mandates. If the subsidies go away, the individual mandate in that state disappears. The employer mandate in that state disappears. Basically, it's a get-out-of-jail-free card from Obamacare. And I think that this was definitely affecting the politics of the case. I have this picture in my slide deck when I present this talk. Protesters outside the court, and they're holding up these signs saying, in Texas, 400,000 people will lose insurance. In New Jersey, 200,000 people. There was actually a brief file that quantified how many people would die because of this. They said, wow, if insurance is eliminated, X people in these states will now die. That's a pretty damning argument. I mean, I think it's legally irrelevant, but the atmospherics, yeah, that's going to weigh on the justices. It's unfortunate, though, because in any other context, right, if this was like, an ERISA statute and Congress said, regulations are available in states that do something, this would have been a 9-0 case, right? In any other context, this is 9-0, easy. But here, because of the politics, it was 6-3, because they even had Roberts and Kennedy go along. Didn't
the late Justice Scalia have a quip in his dissent? He said that if this were a normal case, this issue would be easily resolved, but it's the Affordable Care Act, so it's seen differently. And then he joked,
he called it SCOTUS care instead of Obamacare. Yeah. The law was called SCOTUS care, but Adam just paraphrased exactly what I'm thinking of. So we're on the exact same wavelength.
We're sharing one brain. That's scary. Yeah. So the story of King v. Burwell was about how the agency was interpreting the statute, right? The line about insurance obtained on a market created by a state or whatever. But at the same time that debate was happening, there were other disputes over the process by which a lot of these documents, though not the regulations so much, but there was controversy about what we casually call guidance documents, and you call it government by blog posts. And just if you describe sort of that process of the administration's attempt to pragmatically adjust things on the fly.
Right. So one of the core attributes of the administrative state is the APA, the Administrative Procedures Act. And this sets out guidelines of how agencies can make regulations. And the general course is if you want to make some sort of substantive change, you have to go through notice and comment rulemaking. This is a fairly arduous process. You have to publish in the Federal Register. You receive comments for a certain number of days. You have to actually consider those comments. Not really, but you pretend to consider those comments. And then you publish a rule and you give notice saying in 60 days this will go into effect. Right? This is the normal course. But in the period of, July of 2013 through about, January 20th of 2017, the Obama administration made a number of ad hoc changes to the ACA without ever going through this regulatory process. And
they actually changed the statute, or what do you mean?
Oh, they changed the statute. I'll give you a couple good examples. Instead of just interpreting laws, they basically made modifications. So here's a very fun example. When the ACA was being debated, Senator Grassley, who I know Adam is a fan of, put in an amendment called the Grassley Amendment that said, if you are a member of Congress or a staffer on Capitol Hill, you have to, you're going to get insurance through Obamacare, right? You only get insurance through Obamacare. That was problematic to a lot of members of Congress and their staffers because Obamacare sucks. And for a lot of them who have very high household incomes because their wife is a lobbyist or whatever, right? They can't get any subsidies in the Obamacare exchange. The old government health insurance plan, they got like a 75% subsidy, right? They basically paid pennies. So they were complaining, and this is Republicans too, this wasn't just Democrats. So you had John Boehner and Harry Reid met with the president at the White House under a cover story, so no one would know what it was, saying, please do something about this. We don't want our staffers to lose our insurance, right? So what did Obama do? Through a guidance document released by the Office of Personnel Management, OPM, they said, well, we will create a new rule. And the rule is this. We will designate Congress a small business. And as a small business, you can now buy insurance on the Obamacare Small Business Exchange. And we will give the exact same level of subsidies available before as you get now. Now, my friends, Congress is not a small business in any sense of the English language. Even worse, the statute limits small businesses to 100 or fewer employees. Congress has like 25,000 employees. They said, oh, but individual offices are separate small businesses. Okay, check. The Speaker's staff has about 200 people. Mazel tov, Nancy Pelosi, right? So in any sense of the English word, this was basically ignoring the Grassley Amendment.
So there's two, and he's like Grassley not only because Grassley's a fine man, but also because I'm from the great state of Iowa, like our namesake President Hoover. But I have to get that plug in there. But what you're identifying are two issues, right? One is the substantive issue of how the statute's being interpreted. Then the second is the procedural issue of how the agency is going about making that interpretation into policy, right? And so we see this come up, and actually it's been an interesting debate through the last administration, the one before it, and almost surely the one to come on, or the one that's now in office, on the process by which these policies are made into law.
Right. So the process is very ad hoc, and it doesn't actually go through the notice and comment process. And the problem with this sort of ad hoc rulemaking is that people don't know what to expect. They don't know how to react to it. I'll give another example. During the fall of 2013, as these cancellation notices started spilling into mailboxes nationwide, the government decided, here's what we're going to do. We're going to allow insurance companies to continue grandfathering plans that are otherwise illegal. Right? This is totally against the law. But this was announced in a press conference. The insurance companies didn't even get a heads up at all. So here, even the regulated parties didn't have any idea that there's this new rule that they now have to decide, are we going to allow these policies to be sold or not? The government basically shifted onto Aetna and Blue Cross, this massive decision with zero notice. I have this one bit in my book. The insurance commissioner from, I think, Washington was on the elliptical, right, in the morning. It was like 6 a.m. Washington time. He was watching CNN. He's like, what just happened? Right? The guy was freaking out. Like, did this just happen? At an emergency conference call at like 8 o'clock in the morning to figure out what the hell to do. And the problem with this sort of ad hoc governance is people can't make predictions. They can't plan. And if rules are always being tweaked, it makes it difficult to price policies. So another reason why I said these ad hoc changes undercut the marketplace, if you're an insurance company and you price policies based on Rule X, and then a month later that rule changes, your actuarial scheme is screwed up. Yeah. So this repeated ad hoc changing undermined the ability to have a stable marketplace in ways they didn't appreciate. They were just like, we gotta live today, YOLO, right? Move on and try and live for it.
We've seen this, though, just in recent weeks, right, in the rollout of executive orders, where an executive order comes out and maybe it was written a little bit faster than one would like, and suddenly you have agencies and White House personnel sort of scrambling to creatively reinterpret terms back in a line with sort of functioning policy. And so this isn't just out of a Democratic playbook or a Republican playbook. It is sort of emblematic of trends in government today.
It really is, and this sort of element of surprise is very bad for planning. If you read Hayek, The Constitution of Law and Liberty, and other foundational works, people need to know what the rules are to make their businesses work. And if rules are changing in this sort of ad hoc fashion, it doesn't. I mean, even one of your former fan favorites is Scott Pruitt. And Scott Pruitt's new administrator at the EPA, and he gave a speech last last week, where he said, we need to move back to a formal rulemaking process and not have this informal guidance. Right? Even this, to use another example in the news, the Title IX issue, right? The question of whether Title IX passed in the 1970s in fact creates a rule concerning transgender discrimination. Congress has never voted on this. The agency never put any notice and comment on this. They issued a letter. Literally, they wrote a letter saying, "Dear colleague," and that was a new law. And last night, the Trump administration withdrew that letter, saying that this has not been properly vetted by the public. So there is an important role for public feedback, even if it's ignored. At least let's pretend that we have an impact on the law.
But no, and just one last word on guidance documents. I mean, there is a benefit even to market actors of guidance documents, right? If their choice is between guidance that never changes and guidance that changes all the time, of course they want the steady, the more predictable one. But if their choice is between guidance documents and no guidance at all, and they have to guess how the administration is going to interpret a statute or regulation going forward, that's in and of itself a form of uncertainty, right?
Oh, it is. So a lot of agencies issue what are called opinion letters or agency letters. These serve a very valuable function. It's like, hey, we have this problem, the rule's unclear. We can either A, do something and wait to get sued, or B, seek an opinion letter. I'm fine with opinion letters. There's no problem there. But these sort of nationwide policies that radically realter a statute in ways that are not conceivably related to the text of the statute, that cannot be done in this ad hoc fashion.
What's the bigger problem, the interpretive problem or the procedural problem?
Oh, I think the interpretive problem is even worse. They're breaking the law here, right? The administrative fix for Congress, you guys are now a small business, that's illegal. In fact, there was a challenge by Ron Johnson, senator from your other home state of Wisconsin.
Yeah.
And it was dismissed on standing grounds. There's no standing there. But the judge said, in like a dicta, if there was standing, this is probably illegal, right? You can't ignore the Grassley Amendment and simply say, yeah, you're a small business, go for it. By the way, there's been no movement to rescind that after the presidential election. That's still in effect.
So while this aspect of the Affordable Care Act was working its way through the courts and through the administration, there was another controversial policy, just generally known as the contraceptive mandate. Could you describe what it is and the legal issues that arose around it?
Sure. I'll blow your minds right now. Obamacare does not have a contraceptive mandate. The actual text of the statute, for those of you who have read the ACA, I've read most of it, not all of it, but I've read most of it, the word contraception appears nowhere. What the law actually says is that employers must provide for women, quote, preventive care. What is preventive care? We don't know. Let the HHS figure it out. So Congress punted to the administrative branches to decide what preventive care means, and they decided it means the full range, the full panoply of FDA-approved contraceptives, including the morning after pill, Plan B, Ella, various forms of IUDs. But the problem is, because Congress didn't say a word about contraception, they didn't even consider the religious liberty implications. They didn't even consider it.
Congress didn't, or the administration did?
Congress did it.
Okay.
Yeah. So, for example, the individual mandate, there's a religious exemption. There is. If you belong to these Christian ministries, you can actually get a carve-out from the exemption for the mandate. But for the Women's Health Amendment, there was nothing. Who would need an exemption for a mammogram, right? No one was concerned about this. So the Obama administration issued, again, a series of, this through notice and comment, but pretty ad hoc decisions about who's covered by this mandate. And initially they said, if you are a house of worship that primarily hires and serves people of the same faith, you are exempted. So imagine if you have a church with a soup kitchen and you don't check baptismal certificates at the door. You were not religious enough under the initial accommodation to get an exemption. This is why when Congress doesn't think about these things and the administration does, they're in trouble.
No, but one second though. It's right. It's true that Congress didn't expressly and specifically legislate on this, but they did write the statute in very capacious terms.
They knew what they were doing.
Right, but I mean, why can't you read that as an implication that Congress was delegating regulatory authority to the agency to make its own sort of expert judgment informed by both expertise and political will?
We talk about Chevron step zero here?
Sure. Well, I don't want to bog it down in legal doctrine,
but I think the answer is, as Justice Scalia says, Congress doesn't bury elephants in mouse holes. And for something as profound as religious conscience, if Congress wanted to give the agencies carte blanche to decide which religious groups are and are not exempted, it would have said a word about it. If you look at the history of the ACA, it's all about mammograms. That's all they were talking about, mammograms and colon screenings, right? So I can't read in that ambiguous term this implicit delegation to balance religious liberty in the fashion they did. And that was actually a piece of a Harvard Law Review article I wrote called Gridlock, which you're welcome to review in more detail. But to Adam's question, indeed, Senator Mikulski, who sponsored this amendment, knew exactly what she was doing. They said, if we put contraception in here, we lose Ben Nelson. We lose all the blue dogs, right? Let's just keep this vague and let the administrative state go to work. And as proof of that, at the meeting where this group decided how to define preventive care, who kicked off the meeting? Senator Mikulski's staffer, her lead counsel, kicked off that meeting. This was a fait accompli. They knew exactly what was going to happen. This was a done deal. They were basically punting on a tough question and letting the agency do its dirty work.
Now, this is a point, if I remember correctly, you and I debated as you were writing the article, because like you said, you don't think that Congress was delegating to the agency the power to balance a policy and the religious interests. I don't mean to mischaracterize your point, but
precisely to pick and choose which religious groups get an exemption and which do not. That's the specific question.
Right, and my position was, when we were debating this amongst ourselves, that it's a good thing, I thought, that the administration was thinking about the religious aspects. But I might not like the outcome, but I thought it was better that the administration was trying to strike a balance rather than just going through with blinders on, not thinking about religion at all.
Well, they could have just given a carve-out exemption, period, right? Yeah. The problem here is, and this gets into the weeds of how it happened, but in the White House you had the Catholics. You had Joe Biden and what was the Chief of Staff, McDonough, his name was?
Yeah, I can't remember.
You had two Catholics telling the president, you have to exempt all houses of worship. And then you had the other people saying, no, if a house of worship isn't primarily serving people of their own faith, they shouldn't get anything, right? This is such a profound decision that unless I have clear guidance from Congress, I don't want the government picking and choosing these sorts of things. I don't think it's actually a beneficial debate. And in fact, if you apply RFRA to the statute as written, everyone gets an exemption under Hobby Lobby, right? They're all exempted. By the way, the entire business of the accommodation is ultra vires. They don't have the power to create new funding sources, say we're going to pay for it, they're going to pay for it. It's all illegal. So if you actually interpret the statute to say this is a mandate for preventive care, then anyone with a bona fide religious objection under the Hobby Lobby case is then exempted.
Now, you mentioned the Hobby Lobby case. Your book traces the arc of a number of cases we can't possibly get into, but it's described in the book. Hobby Lobby, and then another case called Zubik, sort of more famously known as Little Sisters of the Poor, as they're one of the co-petitioners. But one thing that I've thought about a lot in watching those cases is there's two ways you could describe the friction that we kept seeing between these religious communities that were challenging the regulations and the administration. And the more, I'd say the darker view of this is that there were affirmatively people pushing the policy who disliked these organizations and wanted to really burden them. It was intentional. But the other, I think the much more charitable view is that they weren't thinking about it in those terms at all. They had a vision of how they wanted to carry out this act, and it was repeatedly bumping up against religious organizations on accident, but almost inevitably. Do you subscribe? I mean, one of the real virtues of your book and the previous book, and you acknowledge this in the acknowledgments, is that you benefited from conversations with not just the people on your ideological side of the case, but also lots of people in government. And so you actually, this book and the one before really give a view into the government's thinking. So again, which approach do you think, which narrative is more accurate?
I think it's good faith all around. Yeah. I mean this sincerely. I don't think the Obama administration woke up and said, you know what, we need to stick it to the nuns, right? We need to screw the nuns. I don't subscribe to that in the least. I think it's a difference of values.
Well, by the way, I share that view for what it's worth, that I do think it was a good faith, it was all in good faith, but then there's an important lesson there, right, about a program of this scope and the regulatory framework that it requires to carry it out, and the impact that it might have on what we call intermediary institutions, right, the churches, schools, organizations, nonprofits, all of these local communities, states, all of these entities between individuals and the federal government that it seemed like had friction over and over again with the federal program.
Yeah, and I keep harping on this point, but had Congress actually addressed this issue, there would have been a blanket exemption for the charities, not an accommodation. By the way, what's the difference between an exemption and accommodation? With an exemption, you don't have to pay for it. It's not on your plan. Your employees don't get it, period. With the accommodation, the nuns don't pay for it, but their insurance plan has to be amended to provide for the provision of these products. That's why they have to sign the form. Now, they're not just signing a form to opt out. What they're signing is actually an instrument under ERISA. It's an insurance law that says we are adding an instrument to your plan. So it actually was a significant change. Had Congress debated this, I am almost positive there would have been a blanket exemption for the religious houses.
That's pretty strong. You don't think they would have struck some compromise, some balance in the middle?
The compromise would have been the government will pay for the meds and we don't have to amend your plan. That would have been the compromise.
But conservatives wouldn't have supported the federal government paying for those plans.
You have Title IX. We already pay for it. We already pay for contraceptive through not Title IX, Title X, I'm sorry, and various federal programs. Or this would have never been passed. They said, we'll figure it out later. If you look at the Blue Dog Democrat debate in 2010, they were paranoid, Bart Stupak and others, about funding for abortion. And this notion that now we're going to start requiring nuns to pay for things they deem abortifacients. Yeah. But Adam's question, though, I think is very well taken, right? Why does this conflict keep happening? Why does this conflict keep happening? And I think the answer is because this is really an issue for the legislative branch, and these various accommodations will leave no one happy. And to bring to the present, Secretary Price is apparently now working on a new accommodation, which will make the other half of the country not happy. Yeah. I'd be just as happy if Congress passed the statute figuring this out, finding a different way of legislating the payment, maybe create a thing on the Obamacare exchange to get easy birth control. I mean, there's a lot of things you can do.
Yeah. I don't know. I think it would, I mean, who knows what would have happened.
Right.
But I just think it's very difficult to guess what the dynamic would have been and where the ultimate, where the equilibrium would have lied. But it's a fair point. It's a fair point. Now, but I want to return to what I just said a moment ago. You had amazing sources for the first book and the second book. I mean, it's incredible because you are no shrinking violet. You have been a vocal critic of the Affordable Care Act and a constant commentator on the litigation as it went. You're both filing briefs in cases, you're analyzing the cases, you're writing legal scholarship, and in all of that, you were able to maintain a very productive and civil dialogue, or at least after the fact, with the lawyers or others. You don't say who for obvious reasons. You don't say who your sources are, but you had very good sources on the other side of the case describing their thinking and why they did things. First of all, how does that happen?
All right. So without revealing too much, let me put it this way: in this town, right? This town. In this town, people want their stories to be told. So it's actually remarkable how willing people are, even in government, to speak off the record for a book. I was pleasantly surprised because they want their story to be told. The difficulty is, if you're having an unsourced story, how do you know if it's credible or not? Mm-hmm. And what I tried to do was to have, to the best I can, someone confirm what someone else said. It was not always possible, and if you look at the book, I hedge in a few places to see that I'm not adopting it, but here's what someone told me. But it's very important to understand that even though we looked at the Supreme Court decision, there are actual human beings litigating it. And these are people making very tough decisions in institutions. And in particular, the Justice Department has institutional concerns that most people never quite appreciate. The Solicitor General cannot make any argument in a brief. His argument has to be vetted by HHS, by Treasury, by the attorney, by the White House, right? All these various layers have to sign off on these arguments. So every single thing that the SG says at arguments is basically vetted and mooted in advance. So when he says something, it's not ad-libbed, it's prepared. Whether it bombs or not, that's a different story. But I tried very hard. And Adam also raised another point that I personally found difficult. For the first book, which I wrote, I was a law clerk at the time this was going on, so I didn't have any public statements, so it was fairly easy for me to be neutral. The second book, admittedly, it wasn't. I wrote briefs in a couple of the cases. I wrote op-eds. I wrote blog posts. I was very critical of these things. And I tried as best as I could to take myself out of it and not make this an opinion book. I tried really hard. One tip for writers is don't use adjectives or adverbs. Describe things with nouns. Adjectives or adverbs let you be lazy and just give your opinion. Nouns don't. So it's a very simple trick, but when you're writing, it forces you to not give your opinion. To describe things with nouns is a lot more work. But I tried really hard. So
in your conversations with folks in the administration, what did you sense about what they learned along the way? Mm-hmm. Right? They were learning on the fly. from the beginning to the end of the Obama administration. Did you get a sense of sort of major lessons learned from inside government?
They view this as a repeat of the New Deal in 1936. And for those of you who don't know what I mean, in 1936, Franklin Roosevelt was confronted with Hoover, right? He was confronted with a bunch of Republican appointees in the Supreme Court who were thwarting his legislative agenda. And he proposed the famous court packing scheme where he would add a number of new justices to basically pack the court. The exact history is far less relevant to what actually it comes to be understood today is when you have a popular president and a Supreme Court standing in his way, the court is wrong. And I think that belief pervaded the Obama administration that this was like the New Deal court standing in the way of this popular president who was trying to enact a progressive agenda. And if you look at President Obama's statements about the Supreme Court, which I go through ad nauseum, which became really relevant now, he was very critical of the court. He said with King v. Burwell, quote, "I hope the court plays it straight." Well, straight, what do you mean, not crooked, right? I mean, there's an implication there. Trump is far more crude than Obama, but I think the sentiments are much the same. If the court rules in a certain way, it's not playing it straight. It's not playing it by the rules. It's playing by politics. And this sentiment pervaded the government profoundly in how they approached the NFIB case as well as King v. Burwell.
Now, when you invoked the New Deal, I actually thought you were going to go somewhere slightly different. FDR famously said that at the depths of the Depression, we were going to try what works. And if that doesn't work, we'll try something else, right? It was a very sort of, I don't want to say non-ideological because, of course, FDR and his advisors had a very specific vision of what they wanted to do. But in terms of actually charting a course to that vision, they were willing to be sort of flexible and pragmatic along the way. I don't want to say flip-flopping, but really changing position if need be to get what they wanted done. And that, I always thought, animated to some extent the Obama administration's approach, that the reason why they were using so much guidance documents, government by blog post, rulemaking, rulemakings reversing other rulemakings, was that they had an endpoint in mind and they were trying to quickly chart a course. Now the question is whether the process, their procedural innovations were justified, I guess.
What a good question. So Roosevelt famously said he wanted bold, persistent experimentation.
That's right. That's the line.
That's exactly what I was thinking of, right? We'll go this way. If that doesn't work, go that way. The only problem is with bold, persistent experimentation, it actually is counterproductive. And there's research on this to show that FDR's policies made the Depression great, right? To make the Depression great again. He actually prolonged the Depression with this constant change because businesses couldn't plan. If there was the new National Recovery Act had a new regulation this week and that week, they could never actually invest in infrastructure they needed to build a business. And I think a very similar lesson prevails for the healthcare law. If this zigging and zagging prevents the insurance companies from pricing out policies a year in advance, it's actually counterproductive. But more fundamentally, the rule of law demands some certainty. And if we get into this notion that the president can simply change the law by a letter or by a blog post, this is the bedrock principle of our law that falls apart. And if I can make this point bluntly, Donald Trump, 2 blocks that way, will use all the powers that Barack Obama gave him to randomly change law. Okay, we can't ban these immigrants, let's ban these immigrants. Oh, let's do this one, let's do that one. It's insane, right? Give an example that liberals don't like. People were literally on an airplane flying to the United States. When they took off, they were eligible for entry, and when they landed, they couldn't, right? That is uncertainty, and that created a lot of chaos. I don't like chaos in the law. I like predictability, and there's been so much chaos these last 2 months. It's been driving me crazy, but he's building on this legacy that we saw in the last 8 years.
Well, something I think about a lot is conservatives who were strong believers in what we call the unitary executive during the Bush years, the idea that the president alone is in control of the executive agencies, and he should be, and the independent agencies. That theory, from a conservative standpoint, was really tested during the Obama years. And now, with President Trump in office, conservatives and conservative lawyers have to get their bearings and decide what they really do believe. You know a lot of conservative lawyers. What's your sense of the sort of the conservative conventional wisdom now on executive power?
I think there are 2 schools of thought, one of which I call the goose gander school of thought, where it's like, well, if it's good enough for Obama, we should do the same. I'm not a fan of that school. I think it's unprincipled. The other school, which I will try to, maybe Adam will give his opinion, is saying it's important to establish principles now so that we can actually assert there is a separation of powers and there is this a role between the governments. We shouldn't simply flip-flop our positions based on whoever's in office. And it's very hard. We have these things called motivated reasoning. We have, behavioral economics. We have these different things which make us very sympathetic to arguments we agree with. And I often try to fight it. Judge Gorsuch, when he gave his nomination speech a few weeks ago, said a bad judge is someone who reaches a result he always agrees with. And always ask yourself, do you ever support policies that, do you ever oppose a policy that if you were voting you would, do you ever actually say something's illegal, but were you a member of Congress, you would probably support it, right? That's your gut check. And for me, at least, with this immigration business, I'm pretty liberal in immigration. I come from a family of immigrants, and I'm not quite an open borders person, but I'm very much in favor of accepting people, refugees in particular. I think it's a good thing to have. But the policy Trump is issuing, I think, is an awful policy. But I think it's probably legal. And if you can actually do that, articulate a policy publicly that you think is awful but lawful, that's your gut check. And it's tough. I'm sure you'll find something where I'm inconsistent on it and I'm guilty as charged, but you can at least try and keep yourself in line.
I mean, I'm glad actually that the tables turn and that people are forced to see it from the standpoint of supporting one administration, opposing the next, supporting another, because it's that old line, hypocrisy is the tribute the vice pays to virtue.
Yeah,
and,
right, exactly.
And I think it's a challenge because of motivated reasoning and so on, to at any given point in time know that you're really embracing a position for the right principled reason, but in the long run, hopefully you'll have sat enough on both sides of the table that in the long run, you and the larger community will sort it out. At the end of your book, you say, to paraphrase Mark Twain, reports of Obamacare's death spiral have been greatly exaggerated. So let's talk about repeal or reform, right? Yeah. When President Trump is elected, suddenly there's this euphoria among the critics of the Affordable Care Act who suddenly think, it's gone, it's going away. What do you think of the prospects for either repeal or significant reform?
President Trump made the same promise that President Obama made. He said no one will lose insurance, right? No one will lose what you have now. This was such a self-defeating promise because that basically means we'll keep Obamacare. If you are actually interested in reforming health insurance, people are going to have to be dislocated. They will. The policies they have now will not be able to stand because they're not very conducive to market-based reforms. But so long as President Trump has this mentality that we need to keep everything the way they are, we can't disrupt people, there's very little that can be changed. But more broadly to Adam's question, what are the prospects of reform? The Democrats are winning the PR battle because they will trot out people on dialysis, people on chemotherapy, people whose lives are literally saved by having this Obamacare. And look, we can't deny that there are people whose lives are improved by this law. It's a fairly small number of people compared to the large number of people who've been worse off. But if we take the mentality that no one will be left off worse than they are now, then what can we do? We're basically stuck at ground zero.
So even if President Trump were a full-throated critic of the status quo and wasn't making these promises about nobody will lose their insurance or whatever, you still think that reform or repeal would be a real practical challenge in current politics?
Right. So it can be done, right? So the key point is, I mentioned this earlier, the ACA was actually finalized through the reconciliation process, which means you only need 50 votes in the Senate. I'm assuming there are 50 votes for something. What exactly, I don't know. But you can't get rid of, well, there's a debate about this, but you probably can't get rid of all the law through this reconciliation process. So if Speaker Ryan can get his caucus to go along, probably. Can McConnell get Susan Collins and these other moderates? Maybe. But how far can you go? If you get rid of the various mandates and the various taxings, then the CBO score goes through the roof because it creates massive deficits. And if the insurance companies aren't convinced this thing's going to be stable, they'll simply exit the marketplaces. So there are a lot of moving pieces. Now, I know Adam's a good fan, as a fan of Paul Ryan. I am a fan of Paul Ryan too, and I'm actually glad he's sort of leading the path. My concern is about what happens in the Senate if they can even get to 50 with reconciliation. I'm not too optimistic. Now, the first book was called Unprecedented. The second book was called Unraveled. The third book will be called Undone, if you will. I don't know exactly what will be undone, something will blow up because the status quo cannot stand.
It might be Undead.
Yeah, that's Adam's. Adam gave me that one. That's a good. That'll be the fourth book. After the zombie apocalypse, we're on Obamacare to help us eat brains more healthy. I think
A greater brain mandate.
this is a book that keeps on writing. I'll be writing about this law probably for the rest of my life, and I don't say that lightly. I mean, I'll be writing about this for a very long time.
The never-ending story. Well,
Yeah,
you've all been very patient. We have a microphone here, so if you have a question, please raise your hand, and Langley will bring a microphone to you.
My name is Laurent Thompson. Quick question. Going back 5 years looking at the ACA, something that doesn't come up enough, and it didn't come up here today. You mentioned that the federal government would offer subsidies. How come nobody says the federal government is broke? So the fact that they're offering subsidies to save the day is really not genuine because the federal government doesn't have the money to offer the subsidies that they're promising.
Right. So the subsidies, let's be honest, is form of welfare, right? You're basically directly subsidizing, directly offsetting a person's bills. And where is this money coming from? Well, Obamacare was supposed to create these massive savings, which frankly haven't materialized. And the thing was supposed to be budget neutral over 10 years. That was always a fiction. This was a CBO hocus pocus math. But where was this money coming from? The Cadillac tax. What's the Cadillac tax? It was a 40% excise tax on generous insurance plans. This was never going to go into effect because this basically puts unions in a tough spot because that's all their benefits. All their benefits are gold-plated insurance plans. So basically, Congress has delayed it 2 years. It'll never go into effect. So the idea that this will be budget neutral was a myth. So the subsidies are simply going to add to the deficit, as the question asked.
Has the pre-existing condition mandate resulted in either people waiting to sign up until they're sick, and has it contributed to the withdrawal from the exchanges by the insurance companies because they were losing money on it?
So by far, the most popular part of the ACA is the provision that says you cannot discriminate against people with pre-existing conditions. And this is one that really tugs at your heartstrings until you look at a supply and demand graph. People are rational, and they cheat the system. And I don't mean that in a pejorative sense. If you are someone with a pre-existing condition, and you know you can buy insurance at any time, you will simply wait. So what people actually did was they would sign up for insurance, they would go get an entire round of chemotherapy, they would then drop their coverage immediately, never pay their bills, and they can't collect them under the ACA. This happens a lot, and the insurance company said these special enrollment sign-ups and drop-offs were responsible for nearly 50% of their costs. There are a small number of people who are very sick who contribute the vast majority of healthcare costs. The way the ACA approached them was say, we're going to put you in the same pool as everyone else, and we'll balance it out. An alternate plan says, okay, we're going to be realistic. We simply segregate you and treat you as a black swan. We're going to put you in this market called a high-risk pool, and we're going to subsidize the hell out of it. And we're going to give you what you need, and that way everyone else is priced based on an average healthy person. This would allow insurance companies to what's called discriminate based on health, for example, but will allow premiums to be more realistic. They're not based on the sickest person. The problem with these high-risk pools is that unless you put a lot of money in, they go bust. So you're going to have a lot of money to pay for some very sick people. There's not an easy answer of how to deal with sick people with the insurance market. There really isn't. But the ACA's idea of a mandate to put people in the market simply hasn't panned out to solve that.
Incidentally, that's one other aspect of the Affordable Care Act debate that's always interested me, that a lot of it wasn't direct welfare, right? It wasn't just payments to the most in need of care. Rather, it tried to create a market mechanism to work through employer-provided health care and then other things. And in a way, that approach, which has some conservative roots, right, rather than going straight through welfare, trying to work through market mechanisms, that in and of itself gave rise to a lot of these collisions between federal power and individual liberty, right? If this were just that's what I'm saying is, if this were just a straight payout,
Single payer, yeah.
If this were, or it was, that's right, it was just a direct welfare payment to the people who needed health care the most, the religious liberty issues would have gone away, yep. The mandate issue would have gone away. Most of those constitutional problems, maybe all of them, would have gone away.
Yeah.
But it was because we wanted to avoid the sort of the big welfare program that we then were in the problem of all the constitutional rights challenges.
Right. So if the government simply said, we will give every American an HSA, health saving account, of $25,000 a year, buy whatever you want, right? They could have done that. The problem with that is the government didn't trust people to make a smart decision. People say, screw this, I'm going to spend the money whatever I want. So this was effectively saying, we are going to nudge you, use your word, nudge you into these gold, silver, bronze plans, and if you don't, we're going to penalize you. And this is how you're going to live, this is how we're going to run insurance. It was a very top-down decision, which used market mechanisms, but based on some very fraught assumptions.
Yeah. Any other questions?
Thanks, Josh. Thanks, Adam. I'm going to stray away from a legal question and ask you a very 30,000-foot assessment of the healthcare market in America. Why do we take it as a sign of accomplishment that health insurance coverage means better health care? Why do we take that coverage equates with better outcomes? Why are there not as many provisions in Obamacare that mandate metrics for performance success in the outcomes of patients? Was this bill intentionally designed to not have an internal way to measure its own success?
Okay, so the second part of your question I'll answer first. There are provisions of the law that measure how long does someone stay at a hospital versus how often do they return, right? So if people go to the hospital or discharged quickly, they're likely to return. So the ACA actually does measure, all right, it's better to give more treatment now than have a return visit a month later. So there are certain metrics. But Garrett's first point, I think, is well taken. Contrary to what common sense would dictate, there's not a close relationship between health insurance and life expectancy. It doesn't. Having health insurance doesn't really make you necessarily live longer on the aggregate. And this one's even more counterintuitive. The ACA was designed saying we need people to stop going to the emergency room, right? They're flooding the emergency rooms. Well, actually, when people are on Medicaid, they go to the ER more because it's easier than going to a Medicaid doctor because they don't have to pay the bill. They just show up at the emergency room. So when states have had a Medicaid expansion, they actually see a rise in the number of ER visits for people on Medicaid. So a lot of the presumptions that this law were built in, I said, were, again, fraught. And when you have this finely tuned Rube Goldberg machine with this mandate and that lever and this market and this regulation, everything has to work together perfectly for it to work, and those presumptions are false, and where's the book? Unravels.
Well, one last thing. Talking about the intersection of how the effect of politics on the court. Let's go in the other direction. How do you think the Supreme Court's decisions, the litigation in this case, how do you think it shaped the politics we now have?
Oh, yeah. I mean, so you had Randy Barnett speaking here recently. Randy Barnett and Ilya Shapiro came up with this theory that John Roberts gave us Donald Trump.
Yeah.
I think that was that maybe was getting at. I don't subscribe to the Roberts-Trump theory, but I do think it is a good teaching exercise. When judges start to base their rulings on things outside the actual legal principle, they can't anticipate the effect of their decision. If John Roberts indeed voted the way he did to prevent the court from being at the center of this storm in election season, maybe he thought it would keep the court out of the limelight. He perhaps was right in the short term, but not in the long term. Because as we saw during the Republican debates last year, whose name did all the candidates mention for the Supreme Court? Roberts. They all said, we do not want another Roberts. In fact, Donald Trump went after Ted Cruz saying, you backed John Roberts. You were John Roberts' bigger supporter. Not true. But you went after Roberts. So Roberts' perhaps effort of trying to avoid this political storm merely delayed the inevitable. And you can be sure that when Judge Gorsuch has his hearing in a couple weeks, they're going to be asking, so are you another Roberts, right? You're a smooth-talking lawyer, really smart. Are you going to cave, right? That's going to be one of the questions he'll be asked. So there is a huge impact when the court tries to engage in this sort of political scheme.
Okay, last question. So the 2009 Tea Party, it fueled not just the politics, but also the legal challenges. We now see a burst of political energy once again in the first year of a presidential administration. Do you see parallels between the two, and do you think then that in turn this current burst of political energy will have effects inside the Supreme Court?
Oh, sure. I mean, you're going to start seeing Justice Sotomayor being the biggest saint of federalism, right? This is someone who dissented in the NFIB case saying it was perfectly fine to coerce states to expand Medicaid. And I'll say, you know what? If San Francisco loses like a $5 million grant, that's unconstitutional, right? But you know what? I'm going along for the ride, right? I'm fine. If these people want to advance federalism, I'll be with you. I'll call them hypocrites when they drop it when Elizabeth Warren is president, right? But God forbid, right? But I do think that there is a constitutional resonance here. They're all saying we need federalism. The states have to have their own choice. They didn't believe this like 2 months ago, but at least now this is their new reality.
Great. Well, again, the book is Unraveled, Obamacare, Religious Liberty, and Executive Power by my friend Josh Blackman. Josh,
I'd be
thank
happy
you
to sign a copy if anyone wants. I'd be happy to.
Great. Well, thank you for coming today.
Yeah.
And thank you all for joining us today. Thank you very much.